Welcome to Mayor Brown's Brexit Snapshot podcast series. This series is designed to provide insight on the latest legal issues related to the UK's new post-Brexit relationship with the EU and keep you up to date on changes to the legislative framework. You can subscribe to this podcast series on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
I'm Rebecca Timms, the Global PSL for the Antitrust and Competition Practice, and I'm joined by James Harrison, an associate who has recently been seconded to our Brussels office.
Hi, Rebecca. Thanks so much for having me. Pleasure to be with you.
Thanks for being here, James. We are now just over 2 weeks into our brand new legal relationship with the EU. The much discussed trade and cooperation agreement with the EU clearly marks a moment of significant legal and constitutional change for the UK, and this will be widely discussed by colleagues elsewhere. Please do check the 1000 portal for commentary on this. However, the subject of today's podcast is the brand new category of domestic legislation called retained EU law. This is essentially a snapshot of the EU law in place at the end of the transition period. It includes all the directly applicable EU law and implementing UK law, which the UK government wishes to keep as we leave the EU. Crucially, it will not include any future changes to EU law, which are not already committed to, unless the UK chooses to mirror these in its own domestic legislation. In today's podcast, we will aim to give you a general overview of this snapshot of law, and as well as where we go from here. So let's start with the recent agreement. After much tortuous negotiation, the new Trade and Cooperation Agreement, commonly referred to as the TCA, gives the UK the right to diverge from retained EU law over time, with the caveat that if the UK makes changes to, for example, employment legislation, which have an impact on trade and investment between the UK and the EU, then the EU may be entitled to impose tariffs or ultimately suspend parts of the trade deal itself, and the opposite case also applies.
I'm just going to jump in here, Rebecca. Thanks so much for that overview. So we've got this new agreement with the EU, but the topic of our talk today is retained EU law. So let's really dig into that, and maybe you could explain exactly what that is.
Well, James, it's made up of EU-derived domestic legislation, such as the UK Working Time Regulations, as well as directly applicable EU legislation, such as the GDPR. It also includes a number of directly effective rights, such as rights under treaties or EU directives, as well as some general principles of EU law retained for the purposes of interpretation. Plus, last but not least, it includes all relevant EU case law at the end of the transition period. Importantly, however, this snapshot is not a complete picture. There are several parts of the existing EU legal framework that are missing. For example, the EU Charter on Fundamental Rights, but also, pretty unsurprisingly, the principle of supremacy of EU law over domestic legislation made after the end of the transition period. It also excludes the EU directives themselves, since they are not directly applicable in the UK. However, it does include any directly effective rights enjoyed under these directives before the end of the transition period, as long as they've been properly implemented in the UK. As with many other issues related to our departure from the EU, it will be for the courts to determine precisely what this means. So there we have a body of retained EU law. But what does the UK post-Brexit legal regime look like beyond this? Over to you, James.
Yeah, thanks, Rebecca. So, as you said, we've got this retained EU law, which is broadly that body of law that we've been upholding as an EU member state, diligently since 1973, just minus a few of those elements that you've discussed. But as the reason we're talking here is that's obviously not the end of the story, and we've got these other new categories of law that are going to radiate out from this starting position of retained EU law. And in grappling with this new landscape, internally, we found it helpful to imagine a series of 4 concentric circles. So in that innermost circle, we've got this original body of retained EU law at the end of the transition period that you've just explained. Now, as you can imagine, there are several parts of retained EU law that just don't make sense now that we're outside of the EU. So we've already started a process of amendment via secondary legislation, these Brexit statutory instruments, which have been made to cure so-called deficiencies in our EU-derived legislation. And these are mainly practical amendments just to make sure that the legislation still works. So let's give you an example in the procurement context, which is one of my practice areas. The UK public contract regulations, in themselves an example of UK domestic legislation that implements an EU directive, they've been amended to replace references to the European Commission with references to the UK Cabinet Office. So that's the kind of example of the practical amendments that have been made at this point. But moving out from this position to the second circle, we've got actually a new body of law that's been created by the need to regulate our exit from the EU and transition to this new relationship. Now, this is made up of the Withdrawal Agreement and the Northern Ireland Protocol, UK domestic legislation that implements that agreement in UK law, and also decisions of the Joint Committee, which was created by the agreement. So let's boil that down and simplify it. Within this second circle, we have brand new sources of law that are just going to regulate the UK legal order and how it will treat retained EU law from the 1st of January 2021 and beyond. Now, since 2018, when a no-deal Brexit was on the table, remember those days, many versions of those statutory instruments have been produced to account for all of those eventualities that might or might not have happened. But at this point, we've got those final versions, and they've been enacted from the 1st of January 2021 to reflect our terms of withdrawal. And as the obligations arising from these new sources of law develop, we're going to see further amendments to the UK regime through secondary legislation. And those amendments are going to need to be made. And I think we can probably expect to see even more now that, theoretically at least, we've got the go-ahead for divergence as part of our trade deal with the EU.
That all sounds good. What about EU case law? We've heard throughout the negotiation period that there should be no role for the Court of Justice in the UK going forward. Is that right?
Yeah, that's largely true. We'll touch on it later, but the TCA is governed by a partnership council and complex dispute resolution mechanisms, which do not include jurisdiction for EU courts. But we're getting way ahead of ourselves there. Let's bring it back. So, as a common law jurisdiction, the UK legal system isn't comprised solely of legislation. We rely on case law to interpret and give meaning to the law and the statute books, and EU law is no different in that respect. So I think, in fact, you could argue that case law interpretation is even more important in the EU law context, because EU legislation is often drafted really broadly to be applied in what is now 27 distinct member states. So just copying and pasting that EU legislation into the UK legal system is only going to take us so far. We need that extra gloss from EU case law to understand how the legislation is going to be interpreted. And we also have this EU case law that existed before the 31st of December 2020, and that forms part of our snapshot that you talked about earlier. But from the 1st of January 2021, UK courts are no longer strictly bound by this principle of supremacy of EU law, as you mentioned. So retained EU case law has now been assigned a relatively high precedent status in the UK, which means that the Supreme Court and the Court of Appeal of England and Wales and their equivalent courts throughout the UK can depart from it as they would do from their own rulings. So in essence, this means that these courts will not necessarily be bound by retained EU case law when interpreting unmodified retained EU law, although they, quote, may have regard to it. So I think here the policy context is going to be really critical. And I think it's possible we're going to see a rapid evolution away from retained EU case law in the next few years. And the government definitely believes that. I'm going to quote from their consultation paper on this topic. It is important that UK courts and tribunals are not bound to retained EU case law for longer than is appropriate. So, clearly the government thinks there's going to be some movement and quick movement away from the position now. And to complicate the picture even further, many citizens now benefit from the withdrawal agreement. So an example is employees seconded to EU businesses and you're a resident in the EU and vice versa, like myself, we're actually entitled to rely directly on the provisions of the withdrawal agreement. And here there is an express role for the EU courts and even retention of the old preliminary reference system. And that's where UK courts can ask the EU courts how parts of EU law should be interpreted. And in the case of the Northern Ireland Protocol, that's still an obligation to make a reference. And as far as we can see, that lasts indefinitely. But that's a topic for another day.
Definitely. So where does that leave us with the snapshot? The picture that was taken on the 31st of December 2020 is already starting to look a little blurry.
Yeah, absolutely. We think there's going to be a period of significant legal uncertainties as we navigate what's being described by so many commentators as a brand new legal ecosystem. I think particularly we expect there to be a number of judicial challenges to the validity of these regulations that are modifying retained EU law. And these regulations are made under, so-called Henry VIII powers. And as the name suggests, these powers have been a feature of our UK constitution for some time now, and allow government ministers to amend primary UK legislation without going through that usual parliamentary ping-pong approval and debate back and forth that we usually see for acts of parliament. So it's quite a serious power. And whilst it appears sensible that these powers should be used in an appropriate way to correct deficiencies that we mentioned earlier, and they are time-limited powers, they will only last for 2 years, I think they're going to present something of a bit of a constitutional headache to the extent that we see them being used to make wholesale and substantive changes to our legal landscape beyond just a few cross-references corrected in the statute book. And we could see these powers being used possibly to remove judicial review powers in certain areas, or just even the implementation of brand new policy making decisions. And let's take it a bit further. We might also find ourselves in the uncomfortable position of being required to comply with what was retained EU law, but from which UK courts have departed from the jurisprudence of the EU courts. And those conflicting interpretations by UK and EU courts of what is essentially the same law will present something of a challenge for businesses which operate in both the UK and in the EU. So I guess fundamentally the question is, how far will EU law still be relevant to businesses in the UK today?
Indeed, we have so far avoided discussing the TCA in detail, but this is the third circle in our imaginary diagram. As we've said, quite how far we will diverge in areas such as employment will depend on the extent to which we're prepared to risk tariffs being imposed if the EU takes the view that this divergence, for example, via a dilution of the working time regulations, has an impact on trade and investment between the UK and the EU. However, even though the TCA does not explicitly mention EU law, this will clearly continue to play a key role in the UK's dealings with the EU. The operation of the new EU Future Relationship Act means that many provisions of the TCA are enforceable in UK domestic law in a similar way the law was previously. This is because it contains a general implementing provision, giving effect to our existing domestic law with the modifications required to implement the TCA. It's important to remember that the UK is departing from a position of total convergence. UK competition legislation, for example, is likely to continue to be influenced by the case law of the CJEU for some time to come. And EU state aid rules will continue to apply to measures which have an impact on trade between the EU and Northern Ireland. As you mentioned before, the Northern Ireland Protocol is another area in which there is an express and binding role for the EU courts. In addition, UK businesses will still be subject to EU rules in certain areas. For example, the European Commission will be able to take enforcement action in relation to cartels and other anti-competitive agreements, where there is an effect on trade between the remaining EU member states.
Yeah, that's a really important point, isn't it? So to the extent that businesses operate or export in both the EU and the UK, potentially they're going to need to comply with two sets of rules where the UK chooses to diverge from the current EU law position. And I think it was interesting to see in the TCA, to the extent we've been able to review it so far, there was only a limited recognition of certain standards, for example.
Yes, indeed. And we're all familiar with the concept of rule makers and rule takers. As international best practices evolve and solidify, we will likely still see EU law operating in the UK in many areas, such as product safety regulation, and also in wider fields such as data protection, competition, environmental regulation, but just packaged in UK legislation.
Well, I've got to say, as we've been EU lawyers for a long time now, that sounds like an incredibly familiar position, just interpreting EU law, packaging it up into UK legislation. Not much change there then.
Certainly does. This leads us to the final circle. Outside of the context of the TCA, how will the UK's own so-called internal market be regulated? Time and perhaps willpower preclude us from discussing the legislation making up this new internal legal system moving forward. However, it is interesting to note that the Internal Market Act appears to contain many elements of EU rules on free movement of goods and adopts them with some modifications internally for the UK. Overall, divergence from EU rules is likely to present both opportunities and challenges for business. On the one hand, it's possible that UK businesses will be in a position to be more competitive than their EU counterparts going forward if there is less red tape in certain areas. On the other hand, divergence may give rise to a number of compliance challenges. For example, incompatible standards, which may mean that differing manufacturing production lines are needed for different markets.
So there's probably three key takeaways from the discussion, and wrapping up now. Firstly, despite the fact that we've left the European Union, EU law is still going to play an important and decisive impact on the UK legal landscape and on businesses directly for the foreseeable future, at least. Those four circles that we've talked about, they represent a new legal landscape which we're all going to have to become accustomed to. So businesses and you and I as lawyers, we're going to need to stay sharp to the opportunities and pitfalls which exist to enable perhaps continued reliance on EU law provisions, for example, in a cross-border litigation context. Secondly, the UK government's key win in the trade deal with the EU was the potential for divergence in many areas, and it's likely to want to make use of that new power pretty soon. And as we discussed, senior UK courts will be free to depart from retained EU case law where they believe it's appropriate and necessary to do so. So this means that ultimately businesses might find themselves faced with some very real compliance issues, which stem not only from being forced to comply with different sets of rules either side of the Channel or the Irish border, as our legal regimes diverge, but also in relation to rules which started out as the same in both the UK and the EU, but which have diverged through different interpretations by UK and EU courts respectively. And thirdly, and finally, it remains to be seen just how far the UK government is willing to push those boundaries in the use of its powers to amend retained EU law using those secondary legislation, statutory instruments that we discussed. I think we can expect to see some legal challenges in the future if the government attempts to enact new policy, for example, without parliamentary oversight through using those powers. And that's only going to, serve to create more uncertainties for business. And that concludes our podcast. We hope you found it useful. It's obviously a complex area of law that we're still navigating. So if you'd like to discuss any of the issues that we've discussed in this podcast or related to Brexit more generally, please feel free to contact Rebecca or I. Our details are on the Mayor Brown website, or contact your usual Mayor Brown contact. And don't forget, you can find more Brexit commentary at mayorbrown.com. Thanks so much for joining us. Thank you, Rebecca.
Thanks very much.
Thank you for listening to our podcast. To learn more about other Mayor Brown podcasts, please visit mayorbrown.com/podcasts.